Sir, we need to detain you for matching the description of a suspect. What? This is a mistake. I'm just heading to a meeting.
Officer David Cartwright had been with the Philadelphia Police Department for 14 years. And in those 14 years, he'd compiled a record that should have raised immediate concerns. 22 complaints, 18 of them involving African American citizens. A black attorney in Rittenhouse Square, accused of loitering outside a law firm where he was a partner. An African American surgeon in Society Hill, questioned about the Mercedes he'd been driving for 3 years, registered in his name. A black professor near the University of Pennsylvania, detained for suspicious behavior while waiting for a colleague outside his own office building. Each one involved an African American professional in a predominantly white area. Each one followed the same script. Cartwright couldn't believe black people belonged, owned, had authority. Each complaint ended identically. Implicit bias training that Cartwright attended, but never applied. One Tuesday afternoon in Philadelphia, his 14 years of seeing criminality in black skin collided with someone Cartwright never expected. An African-American federal prosecutor with a Georgetown law degree. Someone who knew the law better than Cartwright ever would, knew his rights intimately, and knew exactly what Cartwright was doing. And that collision would finally end Cartwright's career, cost the city $1.8 million, and expose a department that had tolerated his pattern of racial profiling for nearly a decade and a half. An African-American man in his early 40s, Assistant United States Attorney Malcolm Harrington, was walking down Walnut Street in Center City, Philadelphia. Attorney Harrington wasn't just anyone. He prosecuted federal cases, corruption, civil rights violations, organized crime. He'd convicted 3 corrupt police officers in the past 2 years alone. He'd just left the federal courthouse after a sentencing hearing. Walking to his car, phone to his ear, discussing case strategy with a colleague, his briefcase in his other hand, his federal prosecutor credentials in his jacket pocket. No crime, no loitering, no suspicious behavior, just walking down a public sidewalk in the middle of a Tuesday afternoon. But Officer David Cartwright saw him through a lens warped by 14 years of unchecked racial bias. Couldn't accept that an African-American man in a tailored suit in Center City could be a federal prosecutor. Couldn't imagine that the black man he was about to confront had the authority to indict police officers, had done it before, and would do it again. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Philadelphia, Pennsylvania, the 5th largest city in America, historic and diverse, where the Declaration of Independence was signed. Center City, the heart of Philadelphia's business and legal district. Tree-lined streets, converted brownstones housing law, firms and boutiques, the federal courthouse towering nearby, where attorneys in $1,000 suits grabbed coffee between depositions, where judges walked to lunch, where prosecutors prepared cases that shaped the city. Median income in this neighborhood, $85,000. Demographics, 71% white. The kind of place where seeing a black face raises eyebrows, where African Americans are immediately questioned about their presence, where people assume the black man in the suit must be a defendant, not the prosecutor. The 1700 block of Walnut Street features upscale coffee shops, law offices, and high-end retail. Federal buildings within 3 blocks. The courthouse visible from where Malcolm Harrington walked. It was 2:45 p.m. on a Tuesday afternoon in October. Clear autumn skies, temperature in the mid-60s, leaves turning gold on the trees lining the street. Professionals everywhere. White attorneys, white business people, white faces that belonged without question. Assistant United States Attorney Malcolm Harrington had been with the Eastern District of Pennsylvania for 11 years. 11 years of prosecuting the most serious federal crimes. Corruption cases that made headlines, civil rights violations that demanded justice, organized crime operations that required years to dismantle. He'd graduated from Howard University, then Georgetown Law, where he finished in the top 10% of his class and served on the law review. His colleagues called him relentless. His supervisors called him exceptional. Even defense attorneys called him formidable. The prosecutor who prepared every angle, anticipated every defense, never brought a case, he couldn't prove. He believed in justice. He believed in the rule of law. He believed that everyone, even police officers who abused their authority, should be held accountable. But he also knew from both professional experience and personal reality that being black in America meant constantly proving you belonged. That racism didn't stop at degrees or federal appointments. That white people, including white cops, saw the color before the credentials. That Tuesday afternoon, Malcolm had finished a sentencing hearing for a public corruption case. 3 years of investigation, 6 months of trial, a conviction on 14 counts. Nothing unusual, nothing exciting, just another day prosecuting federal crimes. He'd left the courthouse, walked the 3 blocks to where his car was parked on Walnut Street. He'd stopped on the sidewalk to take a call from his colleague about an upcoming grand jury presentation. His car was a black Audi A6. Nice, but not ostentatious. Registered in his name, purchased legally, completely legitimate. He belonged there, worked there, had worked in this neighborhood for 11 years, walked these streets 1,000 times. He was doing exactly what thousands of attorneys do every single day, taking a business call between court appearances, standing on a public sidewalk, discussing legal strategy. Nothing suspicious, nothing unusual, nothing that should attract police attention, nothing that would make anyone look twice at a white attorney doing the exact same thing. But Officer David Cartwright, 14 years on the Philadelphia Police Department with 22 complaints documenting his pattern of targeting black citizens, saw something different. Cartwright had been with the department since his early 20s, since 2009. He'd worked various assignments over the years, but spent the last 7 years on patrol in Center City and the surrounding affluent neighborhoods. His supervisors kept him in these assignments despite his complaint history, because, in their words, he knows the area, he's proactive with quality of life issues. What they meant was that Cartwright stopped every black person he saw who didn't look like they belonged, questioned African Americans about their presence in white spaces, treated black citizens like suspects by default. 22 complaints in 14 years, 18 of them involving African American citizens. The pattern was unmistakable. 2016, a black accountant walking near Rittenhouse Square late evening. Cartwright stopped him, demanding ID and explanation for being in the area. The man was returning to his apartment 2 blocks away, lived there for 5 years, worked at a firm downtown. Cartwright claimed he matched a vague description of a robbery suspect, appeared nervous, complaint filed, resolved with implicit bias training. 2018, an African American doctor sitting in her parked Mercedes near Pennsylvania Hospital. Cartwright approached, questioned her about the vehicle, demanded registration and proof of ownership. She was an attending physician at the hospital. The car was registered in her name. She was on her lunch break. Cartwright claimed the vehicle looked suspicious in that location. Couldn't explain why a legally parked car was suspicious. Complaint filed, closed with a written counseling and diversity workshop. 2021, a black graduate student entering a University of Pennsylvania building. Cartwright detained him, demanded student ID and explanation. He was a PhD candidate in engineering, worked in that building every day, had an access card and university credentials. Cartwright claimed there had been reports of trespassing in the area. There hadn't been. Complaint filed, dismissed with cultural awareness training. Every complaint told the same story. Cartwright saw African Americans in white spaces and couldn't accept their legitimacy, couldn't accept that they belonged. He assumed stolen vehicles, assumed trespassing, assumed criminal intent before criminal activity. He demanded proof of belonging, proof of ownership, proof of legitimate presence. Things he never demanded from white people in the same locations, doing the same things. And when complaints were filed, the department responded with training certificates instead of discipline, with workshops instead of consequences, with one more chance instead of termination. Internal Affairs had a file on Cartwright that should have resulted in termination years ago. 22 documented incidents, 3 settlements paid quietly, multiple credible witnesses, 8 sustained complaints. But Cartwright had allies in the department, supervisors who valued his arrest numbers and proactive approach, union representatives who protected him at every disciplinary hearing, and a system that prioritized officer retention over accountability to the black citizens he repeatedly profiled. That afternoon, Cartwright was on patrol near the federal courthouse when dispatch received a call about a suspicious person on Walnut Street. The caller had reported someone who looks out of place, just standing around. Specifically mentioned the person was black. The caller wasn't sure exactly what was wrong, just had a feeling something wasn't right. Cartwright responded immediately. This was his specialty, keeping the neighborhood safe, protecting property values, making sure people belonged. He pulled onto Walnut Street and scanned for the description. Black male, and there, standing next to a black Audi, a black man in a suit, phone to his ear, briefcase in hand. Cartwright's mind made the calculation it always made. Black person plus expensive car plus affluent area equals suspicious. He didn't consider that this could be an attorney between court appearances. He didn't notice the federal courthouse 3 blocks away. He didn't observe that the man was clearly on a business call, completely calm, obviously professional. He saw what his biases trained him to see, a black person who didn't belong, a situation that needed investigation, a potential crime in progress. Cartwright pulled his patrol car directly in front of Malcolm, blocking the sidewalk. Do you think 3 similar complaints within 5 years should trigger automatic termination proceedings? Drop your answer below. Malcolm heard the patrol car's engine, saw the car block his path. His stomach tightened. He'd lived this before. Not personally, but he'd prosecuted officers who did this, reviewed cases exactly like this, knew the pattern intimately. Here we go again. Another cop who can't believe a black man in a suit could belong here. Sir, can I ask what you're doing here? Cartwright called out, stepping from his vehicle. Malcolm turned slowly, his hands visible and open at his sides. Officer, I'm on a phone call. I just left the courthouse. Is there a problem? Cartwright moved closer, his hand resting on his service weapon. I didn't ask where you came from. I asked what you're doing here. I've had reports of suspicious activity in this area. Suspicious activity? Malcolm kept his voice calm, professional, though his jaw clenched. Officer, I'm a federal prosecutor. I work at the courthouse. I'm standing on a public sidewalk taking a business call. You're a what? Cartwright's tone was skeptical, dismissive. A federal prosecutor, assistant United States attorney. I prosecute federal crimes in this district. You have any ID to prove that? Malcolm reached slowly into his jacket pocket, pulled out his federal prosecutor credentials, the badge and identification card issued by the Department of Justice. He held them out. Cartwright took them, examined them with obvious suspicion. These could be fake. They're not fake, officer. You can call the U.S. Attorney's Office. You can verify my credentials. But I'm asking you, what reasonable suspicion do you have to stop me? What crime have you observed? Sir, I'm investigating a suspicious person call. You match the description. What description? Black man in a suit? That's not a description of criminal activity, officer. That's racial profiling. Cartwright's face hardened. Sir, I need you to provide additional identification. Do you have a driver's license? Officer Cartwright. Malcolm read the name from the badge. I've provided federal credentials. I've explained my presence. I've committed no crime, no violation. Under Terry v. Ohio, you need reasonable, articulable suspicion of criminal activity to detain me. Standing on a sidewalk while black is not reasonable suspicion. Are you refusing to cooperate? I'm asserting my Fourth Amendment rights. I'm questioning the legal basis for this stop. There's a difference. A white woman in her 50s, walking out of a nearby coffee shop, stopped to watch. She pulled out her phone and started recording. Another witness, a white man in business attire, paused on the sidewalk. Officer, I've seen this gentleman here before. He works at the courthouse. This is ridiculous. Cartwright ignored them. Sir, I'm going to need you to step over to the patrol car. On what basis? Malcolm's voice remained controlled, but the frustration was breaking through. You have no reasonable suspicion. You have no probable cause. You have a black man on a sidewalk, and apparently that's enough for you. Sir, I prosecute police misconduct, officer. I've convicted officers for civil rights violations. I know what unlawful detention looks like, and this is textbook. Within 4 minutes, another patrol car arrived. Sergeant Lisa Brennan stepped out. a 16-year veteran who'd reviewed Cartwright's file multiple times and tried to push for discipline. She approached and immediately saw the problem. A professional in a tailored suit, federal credentials in hand, being detained on a public sidewalk with no apparent cause. "Cartwright, what's the situation?" "Suspicious person call, Sarge. Subject claims to be a federal prosecutor, but..." "Claims," Malcolm cut in. "Sergeant, I'm Assistant U.S. Attorney Malcolm Harrington. I just finished a sentencing hearing at the federal courthouse. I was taking a business call when Officer Cartwright stopped me without reasonable suspicion or probable cause. I've provided my federal credentials, which he suggested might be fake." Sergeant Brennan took the credentials, examined them carefully. She pulled out her radio. "Dispatch, can you verify employment for a Malcolm Harrington, Assistant U.S. Attorney, Eastern District of Pennsylvania?" 2 minutes later, dispatch confirmed. "Malcolm Harrington, Assistant U.S. Attorney, Eastern District of Pennsylvania, Criminal Division, employed since 2012. Credentials are valid." Sergeant Brennan turned to Cartwright with an expression of controlled fury. "Officer, this is a federal prosecutor. He provided identification. He explained his presence. There's no crime, no violation, no reasonable suspicion. This stop is over." "Sarge, these can be faked. I still have..." "Cartwright, what was your reasonable suspicion? What crime did you observe?" "Silence. Stand down. Now." Malcolm looked at Sergeant Brennan. "Sergeant, I'm Assistant U.S. Attorney Malcolm Harrington, Criminal Division, Eastern District of Pennsylvania. I was taking a business call after leaving the courthouse. Officer Cartwright blocked my path, demanded ID, and when I provided federal credentials, suggested they might be fake. This is racial profiling. This is a Fourth Amendment violation. This is unlawful detention based solely on race." He gestured toward the witnesses with their phones. "Everything is documented. The lack of reasonable suspicion, the racial profiling, all of it." The woman who'd been recording approached. "Officer, I saw the whole thing. This man was just talking on his phone. He wasn't doing anything wrong." Another witness, a white man in his 30s, joined. "I work at a law firm 2 blocks from here. I've seen Mr. Harrington around the courthouse for years. This is harassment." A third witness, a Hispanic woman, added, "I called 911 when I saw what was happening. This looked like racial profiling." 3 witnesses, none of them knowing each other, all saying the same thing. Cartwright stopped a man for no reason other than being black in Center City. Sergeant Brennan radioed for a captain to respond to the scene immediately. Within 12 minutes, Captain Robert Fitzgerald arrived. A 23-year veteran who'd been pushing for Cartwright's termination for 3 years and had been blocked by Union protection and command staff reluctance. He stepped out of his vehicle and took in the scene. A federal prosecutor being detained. A crowd gathering. Witnesses recording. Body cameras running. The obvious disparity between the victim and the accusation. He listened to Brennan's briefing, examined the credentials, spoke with Malcolm, reviewed the initial call, and spoke with the witnesses. His jaw tightened. This was exactly what he'd warned about. This was the pattern he'd documented. This was the lawsuit waiting to happen. Then he turned to Cartwright with an expression of finality. "Badge and weapon. Now." Cartwright's face went white. "Captain, I was just..." 22 complaints, Officer Cartwright. 18 of them, just like this. Black professionals in white spaces. And you couldn't accept they belonged. You just racially profiled a federal prosecutor, someone who prosecutes civil rights violations, in front of witnesses and cameras. He paused, letting it sink in. "I've been reviewing your file for 3 years. I've written memos recommending termination. I've documented this pattern, and this is exactly what I said would happen. Badge and weapon. Everything. You're on administrative leave effective immediately, but let's be clear, your career is over. This is termination. We're just starting the paperwork." Cartwright handed them over, his hands shaking. The weight of 22 complaints, 14 years of warnings ignored, catching up in a single moment. Captain Fitzgerald turned to Malcolm. "Attorney Harrington, on behalf of the Philadelphia Police Department, I apologize. This was completely inappropriate. This was racial profiling. This was exactly the kind of incident we've been trying to prevent. Officer Cartwright will be placed on administrative leave pending investigation. But between you and me, his career is done. I'll be recommending immediate termination. If you choose to file a complaint or pursue legal action, and you should, the department will cooperate fully. This pattern needed to end years ago. Malcolm looked at Cartwright, then at the captain, taking a moment to gather his thoughts. Captain, I've been a prosecutor for 11 years. I've prosecuted police officers for civil rights violations. I know what racial profiling looks like. And your officer just treated me like a suspect for standing on a public sidewalk. He detained me for being black in Center City. He questioned my federal credentials. He couldn't process that an African-American man in a suit could be a prosecutor. He gestured toward the body cameras and witness phones. Everything is documented. The lack of reasonable suspicion, the unlawful detention, all of it. So yes, I'll be filing a complaint. And yes, I'll be pursuing legal action. Not for money, but because if this happens to me, a federal prosecutor with resources and knowledge, imagine what happens to people who don't have my credentials, my platform, my ability to fight back. How many young black men has Officer Cartwright stopped who couldn't fight back? How many people did he profile who didn't have witnesses or cameras? How many complaints would it have taken before someone acted? By that evening, the story was spreading through Philadelphia's legal community and onto local news. Video clips from witnesses' phones went viral. Hashtag racial profiling. In Philly, and hashtag federal prosecutor profiled started trending. Headlines appeared. Federal prosecutor racially profiled by Philadelphia police officer. Officer with 22 similar complaints caught on camera profiling federal attorney. Assistant U.S. attorney detained for walking while black. Witnesses describe obvious racial profiling by Philadelphia officer. The legal community responded immediately and forcefully. The Federal Bar Association for the Eastern District issued a statement supporting Malcolm, calling the incident completely unacceptable and a clear case of racial profiling. The NAACP Philadelphia chapter condemned the incident, demanding termination and systematic reform. Even the Fraternal Order of Police's Progressive Reform Wing publicly defended Malcolm, calling it indefensible and proof that the complaint review system is broken. The U.S. Attorney's Office received hundreds of calls of support for Malcolm, along with demands that the department face consequences. Malcolm hired Sarah Chen, a prominent civil rights attorney who'd won similar cases and secured major settlements against police departments. The lawsuit was filed 3 weeks later, naming Officer David Cartwright, his supervisors who'd ignored 22 complaints over 14 years, the watch commander who kept him in that assignment, and the Philadelphia Police Department. The allegations were comprehensive and damning, racial profiling in violation of the Equal Protection Clause of the 14th Amendment, unlawful detention without reasonable suspicion or probable cause in violation of the Fourth Amendment denial of civil rights. Under 42 U.S.C. Section 1983, intentional infliction of emotional distress, false imprisonment, supervisory liability for failure to train, discipline, or terminate. Despite documented pattern, municipal liability for deliberate indifference to Officer Cartwright's pattern of racial profiling. Violation of Pennsylvania civil rights statutes, the complaint included Cartwright's entire history, presented in devastating detail. 22 complaints over 14 years, 18 involving African American citizens in similar circumstances, affluent areas, professional settings, white neighborhoods, all documented, all investigated, all resulting in minimal discipline, all dismissed with training that never changed his behavior. The lawsuit laid out the pattern systematically, showing complaint after complaint, year after year. Black victim after black victim, similar circumstances, similar assumptions, similar harassment, $1.8 million in damages sought, plus attorney fees and mandatory policy reforms. Philadelphia's city attorneys reviewed the case. The evidence was overwhelming. Security footage showed everything. Malcolm taking a business call, Cartwright's unjustified stop, the escalation. Body camera footage captured the lack of reasonable suspicion, Cartwright's inability to articulate a crime, the racial nature of the assumptions. Multiple independent witnesses corroborated the account. Malcolm's federal credentials proved his complete legitimacy. Cartwright had no legal basis for the stop. No crime, no reasonable suspicion, no articulable facts. Internal affairs files documented the pattern: 22 similar complaints, 18 involving African Americans, all ignored. Every element of a Power 1983 claim was present. Fourth Amendment violation? Check. 14th Amendment violation? Check. Municipal liability for deliberate indifference? Check. Qualified immunity? Unlikely to apply given clear precedent against racial profiling. The city's risk assessment was clear: go to trial and lose publicly, with a jury verdict potentially 3 times higher, or settle now and implement reforms. The city settled 8 months later. $1.8 million paid to Malcolm Harrington, one of the largest settlements in Philadelphia history for racial profiling. Officer David Cartwright was terminated 4 weeks after the incident. The union initially filed grievances, but withdrew after reviewing the evidence and facing public pressure. The termination letter was scathing. Officer Cartwright engaged in racial profiling, detaining a federal prosecutor based solely on race without reasonable suspicion or probable cause. He violated department policy on constitutional policing, bias-free policing, and proper detention procedures. He has demonstrated a pattern over 14 years of similar conduct, indicating this was not an isolated incident, but a persistent failure. His continued employment creates unacceptable liability for the city and violates the civil rights of citizens, particularly African American residents. The letter specifically cited 22 prior complaints showing the same racial profiling pattern, noting that progressive discipline had failed to modify behavior. Employment terminated immediately without appeal rights due to the severity of constitutional violations. Cartwright's name was entered into the National Decertification Index, preventing him from ever working in law enforcement again anywhere in the country. His 14-year law enforcement career ended permanently. No pension enhancements, no retirement in good standing, no law enforcement work anywhere. The union initially attempted to fight the termination, claiming contract protections. The city provided Cartwright's complete complaint file, body camera footage, witness statements, and Malcolm's compelling testimony to the arbitrator. When the public pressure mounted and legal counsel reviewed the liability, the union withdrew the appeal 2 weeks later without comment. Cartwright released no public statement. Malcolm testified before Philadelphia City Council at a packed hearing 3 months after the incident. Dozens of supporters filled the room. Community members wore Hatcher Justice for Malcolm buttons. Local clergy, attorneys, and activists attended. The media documented every word. I'm a federal prosecutor. I've dedicated 11 years to prosecuting federal crimes, to seeking justice for victims, to holding powerful people accountable. I've lived and worked in this city for over a decade. I know my rights. I know the Constitution because I've taken an oath to uphold it. I know what unlawful stops look like because I prosecute them. And Officer Cartwright stopped me for walking while black, for taking a business call on a public sidewalk, for existing in Center City as an African American man. I was humiliated in my own neighborhood where I work, where I prosecute cases that protect this community. 22 complaints over 14 years, 18 involving African Americans. That's not bad luck. That's not mistakes. That's a pattern. That's policy. That's the department tolerating racism. He paused, meeting each council member's eyes. $1.8 million is what it cost to finally remove one officer who should have been fired after complaint 3. But money doesn't undo standing on a sidewalk being treated like a suspect. It doesn't erase the message that my law degree and federal appointment don't matter if my skin is black. And it doesn't prevent the next officer with 22 complaints from doing the same thing to the next victim who can't fight back. This council needs to ask itself, why did it take 22 complaints? Why did it take a lawsuit? Why did it take a federal prosecutor to finally get action? And what happened to all the victims before me who couldn't fight back? Standing ovation from supporters. Several council members visibly uncomfortable. The Philadelphia Police Department announced policy reforms 7 months later, under pressure from the lawsuit and following the council hearing. Police Commissioner announced the measures. Automatic supervisory review after 3 complaints with similar patterns within 36 months. Mandatory termination proceedings after 4 sustained complaints involving racial profiling. Real-time flagging system for officers with patterns of stops involving racial disparities. Mandatory supervisor approval for any stop in affluent neighborhoods involving only suspicious person, calls without specific criminal activity. Body camera footage. Review of 100% of stops involving minority citizens in predominantly white areas. Anti-racism training conducted by civil rights experts and community organizations, not police trainers. Command staff accountability. Supervisors who ignore patterns face discipline up to termination. Community oversight board with subpoena power to review complaint patterns. Quarterly public reporting of stops by officer, race, location, and outcome. Integration of National Decertification Index checks to prevent hiring officers terminated for racial profiling elsewhere. The police union initially opposed several reforms, particularly command staff accountability and the 3-complaint rule, but relented under public pressure. Why do departments wait for the 22nd complaint instead of acting on the 3rd? Why does it take a lawsuit to implement common sense accountability? Comment your thoughts. Reforms to be fully implemented within 9 months, with progress reports every quarter. This wasn't about one Tuesday afternoon. This wasn't about one confrontation. This was about a department that let Officer David Cartwright profile black citizens for 14 years, despite 22 documented complaints showing a clear pattern of racial profiling. The pattern was obvious from complaint 3. A black professional questioned in an upscale area, and saw as African-American resident asked for proof in their own neighborhood. It was undeniable by complaint 10. Same story, different victim. Same bias, different day. Same assumptions, different location. But Philadelphia police kept Cartwright on patrol, kept assigning him to affluent neighborhoods in Center City, kept ignoring the warnings, kept accepting the excuses until he finally stopped someone with the knowledge, resources, and courage to force accountability. Malcolm paid the price. Treated like a criminal outside the federal courthouse where he prosecutes crimes. Detained for taking a business call on a public sidewalk. Humiliated in front of colleagues. The message delivered clearly. Your federal appointment doesn't matter. Your law degree doesn't matter. Your service doesn't matter as much as your race. Cartwright's career is over. Terminated. Decertified. Barred from law enforcement permanently. That's consequence. The city paid $1.8 million. That's accountability. The department implemented reforms. That's progress. But those measures came after 14 years and 22 complaints. 14 years of black victims who didn't have Malcolm's advantages, a law degree, federal employment, institutional support. 14 years of African-American citizens who were profiled, harassed, detained, and had no recourse. No witnesses. No cameras, no resources, no platform, no one listening. How many others did Cartwright stop in those 14 years? How many young black men detained without cause? How many African-American women questioned about belonging? How many professionals humiliated who couldn't fight back? How many complaints never filed because victims knew nothing would change? The real question isn't why Cartwright did this. Racists will racist. The question is, why the system let him keep doing it? Why do departments wait for complaint 22 instead of acting on complaint 3? Why do they recognize patterns after 18 similar incidents instead of stopping them after 5? Why do they prioritize protecting officers with documented racist patterns over protecting the black citizens those officers target? Why does it take a federal prosecutor, someone with credentials white people respect, to finally get accountability? Why do settlements come from taxpayer money, while officers who cause them face no financial consequences? Because if we don't fix the system that kept David Cartwright patrolling Center City for 14 years, if we don't address the culture that protected him despite the pattern, that valued his arrest stats over civil rights, that ignored black victims until a credentialed one fought back, then we're just waiting for the next officer with 22 complaints. The next federal prosecutor. The next African-American professional, who gets profiled for the crime of being in the wrong neighborhood with the wrong skin color. This case represents thousands of others that never make news. Tens of thousands of Black Americans profiled every year by officers who never face consequences. Millions of stops based on race, not crime. A system where being Black is treated as reasonable suspicion. Comment if this should be federal law. Any officer with 3 similar complaints within 3 years faces automatic termination. No implicit bias training that doesn't work. No diversity workshops that change nothing. No progressive discipline that protects racism. Immediate termination. Career over. Out of law enforcement permanently. 3 complaints. 3 similar incidents. 3 African Americans profiled in similar circumstances. That's not isolated incidents. That's a pattern. And patterns should end careers, not Black lives' comfort and dignity. And if you believe these stories matter, if you think 14 years of complaints should result in accountability, before year 15, if you believe Black professionals deserve the same presumption of belonging that white people get automatically, then hit that subscribe button. We're exposing racial profiling. We're demanding real accountability. We're fighting for every Black American who's been profiled, for victims who couldn't fight back, for a system that treats everyone equally regardless of race. This isn't about one officer or one federal prosecutor. It's about a system that gave David Cartwright 22 chances, 22 complaints, 18 Black victims, 14 years, while Black Americans don't even get the benefit of the doubt. It's about departments that protect officers with documented patterns of racial profiling and the African American professionals and human beings who pay the price for that protection with their dignity, their safety, and their constitutional rights.